Hey there, I'm attorney Jason McGrath of the law firm McGrath and Spielberger. I've been practicing law for about 19 years now, primarily now in North Carolina, but also in Florida and Tennessee. And my law firm practices in a couple additional states listed right over my shoulder here. In any case, we're going to talk about responding to a complaint, responding to a lawsuit. And this is more specific toward North Carolina a little bit, but this generally applies to lawsuits in pretty much every state. Again, not specific legal advice here, just some general information, and for your lawsuit you need to talk to an attorney licensed in your jurisdiction and get some very specific and customized advice. But anyway, if you've been sued, you've been served a complaint, you have a time frame, a limited time frame to respond. In North Carolina, that's typically 30 days. And so if you don't respond within that time period, the most common next step is for the other side to file for a default judgment. And in North Carolina, it's kind of a two-step process depending on a few specific circumstances and facts. In other states, it might be a one-step process, whether it's an entry of default and then a default judgment. But the bottom line is that if you don't respond to a complaint and in a timely fashion, there's a very good chance that you're going to lose the lawsuit pretty much automatically at that point. And sometimes if you miss that deadline, you can undo that later and actually be allowed to file a response to the complaint. But that's a dicey proposition. You can't always do it, certainly, and it certainly puts you in a much weaker position if you have to try to cause that to happen. So let's just assume for purposes of this discussion that you've been served with a lawsuit and you haven't responded. Well, typically what's going to happen is that either you or somebody on your behalf is going to go to the other side and perhaps ask for an extension of time to respond. And the opposing lawyer may go ahead and grant that or may not. There's no obligation to grant it, but most of the time, at least, I don't know what happens in cases I'm not involved in typically. In cases I'm involved in where, maybe somebody comes to me and says, oh gosh, I got served this lawsuit 3 weeks ago, I don't know what to do, what should I do? And if I agree to get involved in the case, then I'll typically pick up a phone or shoot an email over to opposing counsel and say, hey, Jason McGrath, I now represent so-and-so, and we're going to look at this case, possibly to reach a settlement. I don't know about that yet. I'm brand new, but can you at least, out of professional courtesy, go ahead and give us an extension of time so we don't need to file a response to the complaint, now or in a couple of days, but rather maybe 30 days from now or something like that. I'm not sure that I've ever had somebody refuse that. It's just a fairly common thing, and usually it's just that the lawyers, if they can, try to get along and be respectful, even if the clients may have very different positions. And so the point sometimes is that, hey, look, if I have to respond to the complaint on your behalf, which means probably filing either an answer or an answer and affirmative defenses, and answer affirmative defenses and counterclaims, perhaps you're going to file a motion to dismiss in there as well. Occasionally, maybe even a motion for more particular statement. There's various ways you can respond. You might even sometimes try and get a case moved from state court to federal court, etc., etc. But the point sometimes is that, hey, look, if I don't have to charge you and you don't have to pay me to actually prepare that legal response, and depending on the circumstances, it can be quite expensive. It can be thousands of dollars. Sometimes it can be less than that if it's a very straightforward case and that sort of thing. But if you can actually dedicate that money toward developing your defense or perhaps even settling the case early on, that could be a better value for your money and a better way to spend your money. So whatever happens, it's almost always a terrible idea to not respond to the complaint. If you don't respond, the other side basically automatically wins as long as they take a few very easy steps. And then you're the low-hanging fruit. They now have a judgment against you, can try to enforce that judgment, perhaps take your property, pursue you for money over a course of years or even decades, literally. So at least if you respond to the complaint, you don't automatically lose as long as you respond in an appropriate fashion. And the case goes on, and you want to have time to develop a defense plan or a plan to resolve the matter, something like that. But ignoring a complaint and not responding is almost always just the absolute worst thing that you can do. So if you need to respond, and even if you maybe are past the deadline it may be that all is not lost. So please consider responding to the complaint. And if you want us to help you with that, certainly contact us, and it's an appropriate case for us to get involved in. And if we agree to do the work, then that'd be great. But we'll see. We'll go from there. In the meantime, good luck to you, and thanks for listening.